associations require we give the addresses of the attorneys on the show, so here we go. Today, Nick DiNardo is with us from the Legal Aid Society. You can get in touch with him, 241-9400. Don Moore of the Moore Law Firm on Nimitz View Drive, moorelaw.com, or you can get all this information by just going to fox19.com and clicking on Moore Law. I think we wanted to talk a little bit about, we wanted to go to Laura in Claremont County, who, Laura, you have a question about a land contract.
Yes, I do. I bought a home in 1997 under a land contract, and during the contract it said that no one can change the price of the home. During this time, she refinanced it for $50,000 more. She went into bankruptcy twice, and it was during the time that the court sent to me all of the history of the house through the court, and this is when I discovered the bankruptcies and the refinances. So she breached the contract 3 times, and during that time she never contacted us every time we tried to contact her. What do we do?
I think you wanted to take this since it was dealing with a land contract, is that right?
Sure. Deb and Laura, there's several things. Number one, your question is very fact specific, and when it's fact specific, what that often means is you're going to have to give a lot of details, and fundamentally, you're going to have a lawyer look at it, a lawyer that does real estate stuff all the time. I can give you some general information. First of all, when you've been in a land contract that long, and or if you put down more than 20% of the original price, your interest in that land changes. What that means is if the land would be sold, if you would decide to sell it, you're the one that gets the equity, which means it's more like a mortgage than a land contract. You get certain rights that vest once you paid down 20% or you paid over a period of time. And I'm not sure what the period of time is. It may be 10 years, but I'm just not sure about that. This is complicated enough. You're going to have to get personal legal advice. Understand that, and for you and others, a land contract is a specific way of purchasing property where you lock in a price, and if the part of the contract is that you've locked in a specific price, you're entitled to enforce that. So the involvement of the bankruptcy court is something that'll have to be determined on a careful legal analysis.
Okay, let's get back to another call now. We have Patty in Fairfield. Patty, you had a question about Section 8 rulings, is that right?
Yes.
Okay, go ahead.
I wanted to ask, my daughter's been in an apartment complex, an apartment for 9 years. The carpet was totally wore out and had never been painted. She's raised 2 daughters there. The landlord is now telling her that she's responsible for $400 of the remodeling. He had carpet laid, he had the apartment painted. Well, actually, she had bought the paint, she had made sure that it was painted. Now, apparently it didn't come out of his pocket, but the carpet did. So therefore, he's telling her she's responsible for $400 of this. I wanted to know, is it true that a landlord, after 4 years or 5 years of living in one apartment, responsible for the paint and having it done, and responsible for the upkeep or replace of carpet that's been wore down and tattered?
Nick, are there some hard and fast rules about that?
There are. This is a really good question because it gets into the difference between ordinary wear and tear, which is referenced in the Landlord-Tenant Act, and damages caused by a tenant. The example I usually give to people is if a carpet becomes worn because it's in a hallway and that's where everyone walks, that is not something the tenant is liable for. If your daughter's children spilled grape Kool-Aid on the carpeting and made a stain, that probably is damage. What you're talking about does not sound like damages caused by your daughter or children. It sounds more like ordinary wear and tear. These are very specific factual issues that have to be looked at, but in this situation, it does not sound like a situation where the tenant would be liable for those damages.
Is that something that you hear very often, Nick, as somebody comes to legal aid because the landlords just aren't taking care of the property?
All the time. Unfortunately, now there are a lot of landlords out there, but when people are coming to legal aid, that's when they have an issue. And that can be a problem where landlords either are not making adequate repairs, or in this situation, they're making the repairs, but they're charging the tenant what sounds like likely improperly for those repairs.
Okay. All right, let's get to another call now. We have Becky in Cincinnati. Becky?
Hi.
Hi.
I lived in a 2-family house for over a year with 1 water meter, And in August, my landlord decided he wanted to start charging me water, so he put the whole house in my name. I called and took it out of my name, and I just moved in October. And then now he's taken half the water bill from May till now out of my deposit. And I was wondering what I could do about that.
The general rule is that if there's only one water meter, electric meter, whatever kind of utility meter it is for a building, and multiple units in that building, the landlord cannot make an individual tenant responsible for that bill. And probably if you're in the city of Cincinnati or have Cincinnati Water, if they were aware of that, that's probably why they wouldn't keep the bill in your name. The general rule is that in private housing, a landlord and a tenant can agree to different terms. So if he said he wanted you to pay half the bill, whether or not that's enforceable is sort of arguable. There's no proof that you're using exactly half the water, but it's one of those situations where there's not a real clear answer in Ohio law.
Nick, tell me a little bit about when is it time for somebody to come to legal aid?
Normally when we see people, it's either when they have extremely bad housing conditions, as you just talked about, or it's an issue where they're facing eviction and they think they have a defense to that eviction.
Okay. Is there anything, we just have a minute or two left here, is there anything you think people should know about, whether they are the landlord or the tenant, about, how to make that relationship work?
Well, I think the title of today is Landlord versus Tenants, and I don't think it always has to be like that. In fact, it's better if it's not the two of them against each other, but the landlords and tenants working together to have a good business relationship and, in fact, a home relationship. So what I always advise people is talk to your landlord, talk to your tenants, try and resolve things, because if you go to court, it's going to be a lot more expensive for both parties, and you're much less likely to get a result that everyone can live with. Whereas if you have a good communication and everyone knows what their rights and duties are, you tend to have a better landlord-tenant relationship.
Okay, good advice. Don?
One more tip that I think is important for everybody to know. When you leave a notice as to where you're going to be, your new address, because you can't get your deposit back, you can't hold them accountable if you don't give them an address. One of our callers mentioned earlier that she didn't know about a judgment. You got to leave them a forwarding address.
All right.
And
Thank you, Don. And next week?
And next week we're having my kid on. He's a board-certified emergency doctor. We're going to talk about medicine and the law.
Medicine and the law. Then we'll have Heard on the Job Veterans Benefits the week after that. Nick DiNardo, thanks for joining us.
Thank you.
We'll be back
Thanks
with
for
more
being
law
here, Nick.
next week. Have a good week.